While underscoring the need for courts to deal with sexual assault cases in a sensitive manner, the Supreme Court has recently issued a slew of directions to trial courts across the country to avoid the agony and the harassment of women who file complaints of sexual harassment. The Apex Court observed that courts across the country must ensure that the process of attempting to bring alleged perpetrators to justice is not onerous for the victims, and that victims should not have to run from pillar to post for the mere registration of a complaint and initiation of investigation, especially when a cognizable offence is prima facie made out in their complaint. A bench comprising Justices D.Y. Chandrachud and J.B. Pardewala opined that courts must be cognizant of the reality that the legal process tends to be even more onerous for complainants who are potentially dealing with trauma and societal shame due to the unwarranted stigma attached to victims of sexual harassment and assault. The bench also highlighted that courts have an important responsibility, especially in cases where the police fail to address the grievance of such victims of sexual violence. So, what are the guidelines that have been issued by the Supreme Court? The Supreme Court directed that in-camera trials should be conducted in all cases relating to sexual harassment. In-camera trial refers to court proceedings carried out in private in the absence of public and the press in order to safeguard the privacy of the parties. Section 327 of the Code of Criminal Procedure mandates in-camera trials to be conducted only in rape cases. This ambit has been expanded by the court in this judgment to also include all cases of sexual harassment. The Supreme Court has also ordered that trial courts must ensure the installation of a screen so that the aggrieved woman does not have to see the accused while testifying, or in the alternative, direct the accused to leave the room while the aggrieved woman's testimony is being recorded. Pertinently, the bench also directed that the counsel for the accused must conduct cross-examination of the aggrieved woman in a respectful fashion without asking any inappropriate questions, especially with regards to the sexual history of the aggrieved woman. It also ordered that the cross-examination may also be conducted in a manner such that the counsel for the accused submits her questions to the court, who then poses them to the aggrieved woman. The court also ordered that trial courts must complete cross-examination in one sitting as far as possible. Significantly, the Apex Court held that a judicial magistrate has the duty to order police investigation under Section 156, subsection 3 of the Code of Criminal Procedure when the complaint prima facie shows the commission of a cognizable offence and the facts indicate the need for a police investigation. Though Section 156 subsection 3 of the CRPC uses the word may, giving discretion to the magistrate to order police investigation, the court held that such discretion must be exercised in a judicious manner. Especially in cases where sexual assault has been alleged and the victim has possibly already been traumatized, the Supreme Court underscored that courts should not further burden the complainant and should instead press the police to investigate. We all know how intimidating it can get when one has to file a police complaint regarding the commission of a sexual offence. Taking this into consideration, the bench observed that the police must be cognizant of the fact that they are usually the first point of contact for a victim of a crime of sexual violence and must therefore ensure that the complainant is at ease and a comfortable atmosphere is created for the complainant. Pertinently, the court emphasized that the police ought not to create yet another obstacle for the victim by declining to register an FIR despite receiving a complaint regarding sexual harassment. Echoing the societal realities that exist, the court also acknowledged that it is no secret that women's families often do not approve of initiating criminal proceedings in cases of sexual harassment, and that victims generally face great societal stigma when they attempt to file a complaint. This Apex Court verdict came while dealing with an appeal filed by an alleged sexual assault victim from Madhya Pradesh, challenging an order of the High Court by which it had dismissed her plea against the magistrate court's order for a police probe into her charge against a person at her workplace. Dealing with the police action in the instant case, the bench said that the police's inaction in this case is most unfortunate and that in every police officer's duty to carry out his or her functions in a public-spirited manner. Accordingly, the court allowed the appeal. Thank you. This is Aratrika Bhaumik for LiveLaw. Keep watching LiveLaw for more such updates.